Hi, wish you a very happy new year and good afternoon. This is a Delhi High Court judgment VOS Technologies India Private Limited versus Principal Additional Director General. It's a batch of writ petition. Question was, issue was inordinate delay in adjudication. What is the effect? That is the issue. The facts of this case in brief. Number of writ petitions were filed before the Delhi High Court questioning the inordinate delay in adjudication. The writ petitioners argued that the delay extended to decades and hence the proceedings are liable to be quashed. More than 10 years delay. According to the department, delay is not a sufficient ground to quash the proceedings or the show cause notices. So the department said the delay was caused by placing the matters in call book. There is a system called a call book system in which they used to place the show cause notices or the pending matters. And this arose because of some decisions of the Supreme Court. The exact issue before the Supreme Court was whether the DRI officers, whether they are proper officers under the Customs Act or not to issue the show cause notices or adjudicate the show cause notices. That was the issue pending before the Supreme Court. Hence, we placed everything in the call book. That is why there is a delay. This was the argument of the department. Delhi High Court considered the Customs Act, Excise Act, Service Tax Law, and the judgments holding the field. The confusion whether DRI officer is empowered to adjudicate was set at rest in a review petition filed before the Supreme Court in Canon 2 judgment. Till that time, the position of the DRI officers to adjudicate the notices remained uncertain. So, department, as per the directions of the board, kept the open and unresolved cases in a call book. The court found that in some cases, the department could not offer any explanation for delay of almost 10 years, even though there was no impediment in proceeding with those cases. The court relied on its previous judgments, which held that where the statute fails to provide or stipulate a particular period, then the principle of reasonable time would apply. This is the crux of the matter. That is, whether if the statute is not providing a time limit to pass orders, then whether the order should be passed within a reasonable time or not is the question. Now, the Delhi High Court dealt with the unsettled position in law. That is, whether DRI officers or the customs officers under the Act or not. The argument of the department was the law was unsettled till Canon 2 judgment. The court noted, Delhi High Court noted, that all the show cause notices were not issued by DRI officers. Even in cases where notices were issued by DRI officers, Delhi High Court said those matters could have been easily placed in the hands of the customs officers who had the power from the hands of the DRI officers. Then you could have passed. That was not done. Delhi High Court said even after the officers were empowered, the DRI officers were empowered by way of Customs Amendment and Validation Act 2011, empowering the DRI officers to adjudicate the department failed to act in terms of the legislative intent. So, law was enacted. The doubt was cleared by that Validation Amendment Act saying that DRI officers are also proper officers under the Customs Act who can adjudicate. Even after that, no action was taken by the department. Despite the legislation, department continued to remain aloof, even though the show cause notices were issued way back in 2006. This is one point which was noticed. Then, with regard to delay in adjudication and its impact, court noted the relevant sections under the Customs Act, Central Excise Act, Service Tax Act, everything they saw. The sections contained words, important, where it is possible to do so. These are the words in the sections. I am not giving the entire sections because the idea is to uh, not to give the too long the judgment. It is 177 pages or so, even assuming 120 pages if you remove the unnecessary things. I don't want to give that huge judgment. I don't want to make it very short, so you miss the juice of it. So the important words considered by the court was the sections stated where it is possible to do so. Officer has to pass the adjudication order within a specific period of time, say 6 months or 2 years. The time limit varied 6 years, 6 months, 1 year, or 2 years. The court relied on a judgment in Swatch Group, which said that where it is possible to do so, that those words, it is applicable only where the proper officer faced insurmountable exigencies and further recourse being rendered impracticable or not possible. It held that the leeway provided by the statute when it employed the phrase where it is possible to do so could not be equated with lethargy or an abject failure to act despite there being no insurmountable factor operating as a fetter upon the power of the proper officer to proceed with the adjudication. This was said in Swatch Group judgment. Then the court relied on another Supreme Court judgment in Union of India versus Citibank, where the Supreme Court held that it would be unfair and unreasonable to exercise the powers in respect of transactions which occurred more than 8 years ago. This is also very important. If the transactions happened 8 years ago, you cannot try to adjudicate the matters now. That is what Supreme Court said in Union Bank of India versus Citibank. Then it relied on the Delhi High Court relied on another judgment of Supreme Court in SEBI versus Sunil Krishna. Supreme Court in that case said authorities must act without undue delay to prevent injustice and abuse of power while ensuring that the statute's objectives are met. Supreme Court said public interest demands that stale matters are not pursued unnecessarily, and objections to delay must be fairly and rationally considered. This is what Supreme Court said in the SEBI case. Then the court came to call book issue, because the department said we used to keep everything in the call book and then we will retrieve it and then issue notices and adjudicate. This is what the department said. The court noted that the department adopted a repetitive exercise of placing the matters in the call book mechanically without application of mind. Further, the Delhi High Court said the procedure is while placing the matters in the call book, the assessee or the taxpayer, the concerned assessee or the taxpayer, he must be put on notice. Sir, I am going to place this because of this issue. Then they have to undertake a periodic review of those cases. These are all based on some board circulars. This was also not done by the department in the set of cases before the Delhi High Court. Finally, the court concluded saying that Delhi High Court said department is bound and obliged in law to conclude adjudication with due expedition. The words where it is possible to do so cannot be countenanced as a license to keep matters unresolved for years. The flexibility cannot be construed as sanctioning lethargy or indolence. A statutory authority, when faced with such a challenge, would be obligated to prove it was either impracticable or constricted by factors beyond its control, which prevented it from moving with reasonable expedition. This they have to prove. They can't simply say, no, no, sir, it was beyond our control. so we could not pass it. We put it in the call book. No, no. You have to prove it. You have to offer explanation why you were prevented from issuing the notice or adjudicating it. The court said this is very important, that this principle will apply to customs and CGST acts. So all the acts, wherever it is there, if there is unreasonable delay in issuing notice or passing orders, then the court said the principle that you have to explain for the delay will apply. Then with regard to the facts of the writ petitioners cases, the court said that frequent placement of matters in the call book, retrieval therefrom, and transferring it again to the call book defies logic. There is no logic in it. It is also demonstrative of non-application of mind by the authorities. Further, notice to assessees, as contemplated by the directives of the board, was not issued. Periodic review was not undertaken without any explanation. The submission of the department that the assessees failed to cooperate in the adjudication by seeking frequent adjournment. This was rejected by saying that in such cases, authorities could have passed the ex parte orders. Oh, why you are wanting them to present themselves? You could have passed the ex parte orders. That is what the court said. Delhi High Court quashed all the show cause notices and final orders passed against the assessees because there was a huge delay. So, I want to place my comments on record. I agree. Even if whether I agree or not, I have to abide by the court judgment. So, but the reasoning is fantastic. The huge delay really causes trouble for the taxpayers. At least now computer systems are there. Records can be maintained. But those days, it was hard copies of the records. So, people were finding it difficult to maintain the records. Law is government records are always correct unless it is proved otherwise. So proving it to be wrong, it's very, very difficult. Nowadays, personally, I feel maintaining records in computer is also extremely difficult because the data is getting corrupted. Some of my data in the pen drive totally got corrupted and it is not even opening. So, or the hard disk failure, crash, that is also there. So, that is one point. Even though other techniques are also available in computer, which I am not a computer wizard, neither a law wizard also. Then the other point is, my respectful question to all the courts is, what about the huge delay in deciding the matters by honorable courts? Delay in adjudication beyond 10 years affects the parties. I fully agree. 100%, there is no doubt. What about the huge delay in deciding the matters by the honorable courts, from the lowest forum to the highest forum? I fully know and understand. I am not saying courts are not under pressure. Huge number of cases. The list is 105, 110 in the court. And if you ask me, who is the one person who is wasting more time in life, I would say, sorry to say, advocates. We sit in the court from morning 10 to evening 4:30 without any work, and the case may not reach. So the entire day is wasted. Just sitting in the court. You can't talk, you can't do anything. You can say you can draft something, but for persons like me, I need a silent place. I cannot sit even in the advocate association room and watch now and then watch the dashboard whether my court is reaching or not. And once I went to the court, I didn't know that a few people have taken adjournment. My case reached and got adjourned also. So most of the time, the one who wastes most time is the advocates. Entire day. Suppose my case is not reaching several months. Consumer NCDRC, each adjournment is given for 6 months. Each adjournment. But the more accumulation of cases, the more the delay. And the court itself says, justice delayed is justice denied. My humble submission to the courts is not a system correction required. A complete revamping of the system, a new thinking, Is it not necessary for the courts to avoid the delays? So whatever I say, will it not applicable to me also? That would be my respectful question to the courts. I don't mean any disrespect to the court. I'm asking myself. This is the question. With that, I will finish off this. Thank you very much. Have a wonderful year.